and pleased to invite Honorable Mr. Justice B.V. Nagarathna, our distinguished chief guest, a beacon of inspiration for generations to come, for a formal address. Ma'am.
Namaskar and a very good evening to everybody. At the outset, I'm really happy, I must say, to be frank, about the overwhelming references made to me. I really do not know whether I deserve all that. Both the chairperson of the governing council of this institution and Justice Sonak have been really generous in showering praises on me. This only makes me more focused because I should continue to do so and not be just, be flattered in the sense of saying that I am great. So at the beginning, I must say I'm not at all great. I don't know whether I deserve all this, but anyway, I accept it with all humility. So with that, I must say that first of all, address the honorable judges who are present here, Justice M.S. Sonak, Justice Bharat Deshpande and Justice Valmiki Menezes, judges of the Bombay High Court at Goa. Then Mr. Dattaraj V. Salgaocar, Mrs. Salgaocar and his family, the management and governing council of the college, Shri Professor Venkat Rao, Professor Yashomati Ghosh, whom I know from the NLS days, Shri Gilman Kulo Pereira, I hope I've pronounced it properly, the President of the Bar Association, learned senior advocates and members of the bar, dear students, invitees, members from the press and media, ladies and gentlemen. I must say that I am delighted to be in Goa, which is a state known for its picturesque beauty, and this college, which is also situated very close to the Miramar beach, and the warmth, the lovely sunshine and the hospitality. Getting away from Delhi to be in Goa in winter is really something which every Delhiite wishes for. And I must say that I am now a Delhiite. I'm also delighted to be on a very important and historic occasion as far as VM Salgaocar College of Law is concerned. I thank you all for the invitation and for inviting me to this Golden Jubilee celebrations of the college, established in the year 1973 as the first law college in Goa. It is a pioneer in the field of legal education. I thank the principal, Dr. G. Shabir Ali Ji, and the vice principal, Dr. Kim Kuto, for extending the invitation to the Golden Jubilee celebrations of the college. Colleges such as the VM Salgaocar College of Law, which is a higher education institution devoted to excellence and equity in the legal education, research and training, are critical to a constitutional republic. The college, which was inaugurated in the year 1973 by the revered father of the present chairman of the college, has made remarkable contribution to the constitutional culture and legal profession in the state. We just heard Justice Sonak say that the number of legal luminaries who have passed out from this college, including Justice Sonak. I am impressed that the idea of equality has actually been actualized in this college, since more than 70% of the students, I am informed, are girl students. We heard from Justice Sonak the Belva Lockwood story and the Ruth Bader Ginsburg story, and their struggles and successes. Let me tell or address the girl students here at this point to say that there are three aspects. Many girl students or women get into the legal profession, there is no doubt about it, or even the judiciary, but very few get up or reach the higher echelons of the profession or the judiciary. Why is that? The reason is that a woman is conceived to have the responsibility, the pigeonholing of a woman to have the responsibility of the family, which should come above all, over and above her profession, her career. And many a time we have seen that women, soon after their marriage and having children, the women advocates do not return to the profession. There are very few who return, but they return back because they cannot survive in the profession for long. One of the reasons is the pulling of the strings from the home vis-a-vis the children and the family, and at the same time the pulling of the strings from the system and the clients, the nature of work, the long hours, responsibility, uncertain day. You never know how your day goes. In the morning, any lawyer would know. He would get up, get ready, go to the office. He thinks that he has a very good case and the judge is not sitting on that day. It goes to another bench where he would not get relief. Sometimes the lawyer goes to the court and he thinks he has a very bad case, but the judge makes out a point for his case. The way the day proceeds for a lawyer is so uncertain. And within that uncertainty, lawyers have to work day in and day out. The best part of their day is wasted in waiting for courts, for the cases to be called. And they are not able to do much work. But thanks to the technology, they are able to work even in the court with the laptops, etc. You consider how it is for a woman then. She doesn't know how or when she would go back, at what time, if she is a full-fledged advocate. The family is waiting for her. And I sometimes tell that higher the degree of success, greater is the degree of guilt in a woman. But I must say that personally speaking, I'm lucky because I have a very nice family. My husband, Mr. Gopal Krishna, has taken so much of the domestic chores because he has given importance to my work. Not that he doesn't give importance to his work, but he understands that the nature of my work is such that he has to cooperate. And so you all know that they say behind a successful man is a woman, but I would say behind a successful woman is a family. So it is for us women advocates, women students who later become women advocates, how we advocate ourselves with our family to get the best cooperation. That is something which rests in each one of us. With these few words for the girl students, I proceed to once again congratulate the governing body, the principal and staff and students of the college as they embark upon their Golden Jubilee celebrations. 50 years in an individual's life is not so significant. It may be significant for that person, but 50 years in the life of an institution is something of a milestone, because ultimately we human beings, we are mortals, but institutions have a perpetual succession. They are immortal, and it all depends on the future generations to come, the governing councils, the teachers, the faculty, the staff, the students who come year after year in the institution, as to how they would carry forward the milestone from year to year. I therefore, while congratulating VM Salgaocar Law College on its milestone of Golden Jubilee, I extend my greetings and good wishes to each one of the persons who are associated with this college, so that the college races ahead from 50 years to 70 years and to the centenary and beyond. I wish the year-long celebrations organized by the college all success. Given the vision and the mission of this college, I thought I'll speak a few words on the theme of transformative constitutionalism, which is a subject not only dear to me, but dear to so many persons who are interested in ensuring that the Constitution is perpetuated in this country. As citizens of a constitutional democracy, we must recognize that our Constitution is not just a document or a legal document establishing institutions of governance. It bears as its core the anti-colonial founding ethos. We must always consider the social, economic, political, and historical background in which the Constitution came and it took its birth. But before expounding further, let me get a little local. I would like to take note of the historical significance of the day, that is yesterday, which marked the 62nd anniversary of freedom from colonial rule for the people of the state of Goa. The transformative character of our Constitution is borne out from the fact that within 9 months, the principle of universal adult franchise was realized for the first time in Goa during municipal and local body elections. Whereas during the colonial rule of Goa, no more than one political party approved by the colonial power was permitted to contest elections. Whereas the transition of power in Goa guaranteed substantive and multi-party democracy. I must say here that multi-party democracy is one of the basic features of our Constitution, and it is only when the multi-party democracy is strengthened that the whole ethos and spirit of democracy would be strengthened not only under the Constitution but in our country as a whole. As I said, the Constitution of India has a profound transformation to our society, our governance. The political change was brought about by two legacies of injustices that prevailed, and the Constitution sought to transform them. The first is the transformation of the legal relationship between the individual and the state after the enforcement of the Constitution on 26th January 1950. It transformed the subjects of the colonial regime to citizens of a country or a republic. It replaced the colonial logic of governing the population with democratic logic of popular sovereignty and public participation. Apart from the universal adult suffrage and structures of parliamentary democracy, the transformation was expressed with a tectonic shift in the constitutional philosophy by having the rights, or the chapter 3 fundamental rights, which is an elaboration of what is there in the preamble of the Constitution. Justice Sonak referred to the preamble of the American Constitution as well as the Indian Constitution, which begins with "We the people." I think our Constitution, when we say "we the people," we mean every person in the landscape of India. It does not exclude anybody. It includes everybody. The preamble itself is so poetic, and therefore the elaboration of the preamble in the rights chapter is what I am going to touch upon briefly. Transformative constitutionalism, even today, seeks to transform social relationships on which legal and political edifices rest. The label transformative actually came up with the South African constitution being inaugurated in the year 1996. One of the American academics, Carl Clare, in his book titled Legal Culture and Transformative Constitutionalism, wrote, and I quote, "Transformative constitutionalism connotes an enterprise of inducting large-scale social change through non-violent political processes grounded in law." I would say that India's struggle for independence, having its hallmark as non-violence, the Satyagraha mode, is the precursor to the constitution, where after independence, in a most non-violent manner, in a most peaceful manner, we have transformed ourselves under the rights chapter, the directive principles of state policy chapter, and the transformation does not end, has not ended, and will never end so long India continues to remain as one integrated country. The goal of a transformative constitution is just not to heal the wounds of the past, but to have a better future. Democratic egalitarianism, recognition and protection of rights, peaceful coexistence and development opportunities are the hallmarks of a transformative constitutionalism. In this regard, I would like to just speak about the interpretation of the Constitution as such, the vision that it has, and then proceed to the substantive content of my speech. The Constitution is considered to be a living tree. We all know the living tree approach, which has been invoked to justify, for example, the expansive rights of Article 21. It is an evolving document. It is not static. It was not made for only the 50s or the 60s. It will continue to remain so long as all of us are loyal to the said document. Transformative Constitution attaches much sanctity to the text of the Constitution, its structure, and the historical moment of its framing. While the text, structure, and history are crucial blocks of constitutional meaning, it does not accord an overriding veto to any of them. The framers were so conscious about the words they chose, which expresses principles that would endure. The task of constitutionalism is to identify and express those founding principles that constitute the framework within which constitutional interpretation is to be carried out. Now, we have spoken about the Constitution having three different vehicles to carry out the items of its transformative agenda. They are, in simple terms, we say the three organs of the state: the judiciary or the courts, the popular democracy or the legislature represented through the parliament, at the executive, which is in charge of achieving distributive justice, attainment of independent socio-economic rights, and good governance. The goals of transformative constitution must be reflected in all these three organs as they function in their respective fields. The role of the courts as enablers in this field, I think, is significant. Broadly speaking, there are three themes in the transformation that the Constitution involved. To this audience, I need not stress a lot about it, for they are equality, fraternity, and liberty, which are so poetically mentioned in the preamble of the Constitution. Equality code is contained in Articles 14 to 16 of the Constitution. Gender equality, autonomy as regards sexual orientation, affirmative actions, and reservations are some of the aspects which are strands of transformative constitutionalism in the Equality Code. Equality Code enshrines the vision of substantive equality as opposed to mere formal equality. The second theme is fraternity. in dealing with economic exclusion, social boycotts and religious excommunication, and workplace exploitation. This theme recognizes that liberty and equality are threatened not only by concentrated state power but also by private orderings that have the potential to block certain individuals' access to the basic goods that are necessary to sustain a dignified life. The principle of fraternity is important not only within the household in a private space but also outside the household in public space. The third theme is liberty. The Liberty Code is contained in Articles 19 to 22 of the Constitution. The theme explores the transformative goal of the Constitution, which views the state as an enabler of individual freedoms and as vehicles of social transformation. Coming back to the Equality Code, I may say that the transformative constitutionalism envisaged attainment of substantive equality by recognizing and eliminating all forms of discrimination that may have existed or that may come about in future. Recognizing the importance of law reform as a catalyst for social change and the significance of rights in remedying the harsh inequalities of colonial India with its division of class, caste, gender, religion, etc. The Constitution emphasizes the importance of universal human rights, principles of equality and non-discrimination. Because of this very reason, it is because of this very reason that a number of historically exploitative practices have been brought down by progressive social reform movements, legislative developments, and by innovative judicial interpretations. I shall touch upon one or two of such judgments of the Apex Court. Anuj Garg versus Hotel Association of India is important inasmuch as it interpreted Section 30 of the Punjab Excise Act 1914 to hold that it was unconstitutional and anti-woman and against gender justice. There was a provision, that is Section 30 of the Act, Punjab Excise Act 1914, which said that a man under the age of 25 years and any woman in any part of the premises selling intoxicating drug or liquor cannot be enforced. It was contended that it was a very benign provision as far as women are concerned, having right to special protection under Article 15(3) of the Constitution. In that case, you must know Article 15(3) actually states that where affirmative action in favor of women are there, the same cannot be challenged as being discriminatory. But here the contention was the reverse, that in order to protect women who are weak, who have to be protected, who need security, and they cannot work in a place where liquor is sold, and having regard to 15(3) of the Constitution, the provision was constitutional. The Supreme Court was bemused with this argument. The decision in Anuj Garg meant more than just striking down the law. It was for the first time the Supreme Court seriously engaged with the meaning of constitutional imperative contained in Article 15(1), that is, no discrimination on the base of sex. Anuj Garg initiated a jurisprudence whose impact extended far beyond the Punjab Excise Act and which became the foundation for a transformative constitutional vision of gender equality. Recently, last year, sitting with Justice M.R. Shah, I had the occasion to write a separate opinion. Not because I disagreed with Justice M.R. Shah, but I wanted to write the opinion since the provision of law, that is the proviso under the Income Tax Act, to say that a married Sikkimese woman will not have the exemption of payment from payment of income tax, but an individual, that is an individual Sikkimese, would have. I wrote because they forgot the fact that an individual would include an individual Sikkimese woman. They did not include Sikkimese woman within the concept of individual, but said that If a Sikkimese woman married outside non-Sikkimese, then she will lose her exemption to pay an income tax. But on the other hand, if a male Sikkimese married a non-Sikkimese, he would not lose that exemption. So marriage became the basis of discrimination. It could be a basis for classification also, but there it became a basis of discrimination, and particularly when they lost sight of the fact that an individual would encompass a woman. An individual encompasses a woman as much as it encompasses a man or any other gender. So I wrote that, and for the sheer what you say engagement with the concept of gender justice, we struck down that proviso. The decision in Anuj Garg has also brought about the course correction which is necessary in Narges Mirza. I need not go into Narges Mirza, but students of law would have known about that judgment with regard to the air hostesses case, where they had to take permission before getting married. I suppose they had to take permission before getting pregnant also, because if they got pregnant within 4 years of their marriage, they had to give up their employment. So that was the kind of discrimination that was there. But there again, the court at that time in 1981 said, no, it is all in the interest of family planning and it is in the interest of women, and therefore they upheld it. But it requires a course correction. But if you come to the 21st century in Babita Punya and Colonel Nitisha, the Supreme Court has said with regard to women engaged as short service commissioners, they must be given the permanent commission, just like the men are given in the Indian Army. And in Nitisha, they also said with regard to the high threshold that has to be met with regard to the medical tests for getting a permanent commission, there must be a separate parameter for women because of the physiological changes that take place in a woman's body due to the natural process of aging, hormonal activity, pregnancy, etc. And the medical criteria ought to be separate, was what was stated by the Supreme Court. When we come to the directive principles, namely Article 38, 39, 42, etc., it is known that these principles have been there, which are actually an elaboration of the basic human rights and to right a colonial wrong or the ancient wrongs, and the equality that is sought to be established there is on par, whether it is a man or a woman. Moving further in the Equality Code itself, I would say that in Nalsa versus Union of India, the Supreme Court, in its zeal to have the transformative constitutional principle entrenched, stated that decriminalization of homosexuality must be made. There must be a radical reimagination of the constitutional promise that the state shall not deny to any person equality before the law or equal protection of the law. The judgment upheld constitutional morality over social morality and norms to ensure that the lives of citizens belonging to the LGBTQ community are not pushed into obscurity by repressive colonial law, and in which case Justice Chandrachud, the present Chief Justice as he then was, noted, quote, is an anathema to the constitutional guarantee of equality, liberty and fraternity. Equality, as the Supreme Court reminds us every few years, forbids class legislation but does not forbid reasonable classification. In the context of public employment, we all know Article 16(1) states about the equality of opportunity in matters relating to public employment. Article 62 prohibits discrimination on the ground of religion, race, caste, sex, descent, place of birth or residence. But Article 64 authorizes the state to make special provisions for reservation in appointment of posts in favor of any backward classes not adequately represented in the services of the state. In the case of Nalsa versus Union of India, in the context of Article 16(4), the Supreme Court directed reservation for persons belonging to the transgender community in the state employment. So together these cases I discussed are based on are on the basis of gender-based discrimination, equal moral membership, equality in matters of public employment, which reflect the transformative potential of the Constitution's Equality Code. I next state about the second theme, that is fraternity. Fraternity is one of the grand ideals enumerated in the preamble, together with justice, liberty, and equality. While there is little doubt that humankind in general and our country in particular has made gains in the struggle for justice, liberty, and equality, the progress towards fraternity has not been rewarding. Horizontal discrimination, that is, discrimination suffered by private entities at the hands of other private entities within the household, as I said, and outside, proscribed by markers like sex, by constitutionally prescribed markers like sex, race, caste, religion, place of birth, is antithetical to the value of fraternity. Fraternity as a leveling instrument reverses the socialization of biases, discrimination, and power predominance in society, along with liberty and equality. But transformative constitutionalism calls for a realization of full human potential by way of cultivating positive social relationships, and fraternity being the vehicle for achieving this agenda. I think that fraternity is especially significant in order to deepen our democracy and its values. Moving on, liberty is one of the most elementary goals of transformative constitutionalism to maintain and strengthen the principles of our humane constitution. Recognizing the right of liberty is therefore a central nerve to the constitutionalism aspect of our constitution. As a nascent democracy, the Supreme Court had faced several challenges in its initial years in performing its role as the watchful guardian of our democracy. In 1915, A.K. Gopalan was State of Madras. The Supreme Court had the occasion to scrutinize the law governing procedural fairness with reference to the expression procedure established by law in Article 21 of the Constitution. Rather than expanding Article 21, the court narrowly construed it as providing only a guarantee against executive action unsupported by law. However, this underwent a total metamorphosis in Maneka Gandhi versus Union of India, wherein the court took the earlier existing strand of jurisprudence to an expansive ideal and observed that Article 21 would not mark the journey's end in determining whether the procedure adopted by law is fair, just, or reasonable. That a procedure which meets the mandate of Article 21 was still subject to challenge under Articles 14 and 19. This judgment has many proteges to boast and has enabled the creation of right to privacy, right to health, right to healthy environment, amongst others. The Supreme Court assumed a new role as the institutional ombudsman of human rights in India, particularly after the emergency years. The decision in Maneka Gandhi became a starting point, a springboard for a spectacular evolution of the law relating to judicial intervention in various cases. Further, the Supreme Court, speaking through Chief Justice Y.V. Chandrachud, gave enforcement to fundamental rights the momentum it needed to combat state lawlessness in Rudal Shah versus State of Bihar by granting cash compensation to a victim of unlawful incarceration. Subsequent to the decision in Rudal Shah, compensatory relief has been granted in several cases. These judgments demonstrate the sanctity attached to personal liberty and the bouquet of rights associated with it, including the right to bodily integrity, the right to die with dignity, right to reproductive choice, right of self-determination of gender, right to privacy, etc. My next aspect of the presentation is with regard to how public interest litigation as a vehicle has been to secure the Constitution's transformative goals. No discourse on our transformative Constitution would be complete without the reference to transformative jurisprudence or public interest litigation of the Supreme Court and High Courts. Public interest litigation, or PIL as it is called, has thrown open the doors of the courts, particularly the Supreme Court and the High Courts. PIL is the incarnation of judicial activism in its people-oriented litigative dimension. Under trial as well as convicted prisoners, women in protective custody, children in juvenile institutions, bonded and migrant laborers, unorganized laborers, scheduled castes and tribes, landless agricultural laborers who fall prey to faulty mechanization, slum dwellers and pavement dwellers, kins of victims of extrajudicial executions, these and many more groups now flock to the Supreme Court seeking justice. They come with unusual problems, never before so directly confronted by the Supreme Court. These concerns are to be remedied by rather extraordinary remedies. And sometimes there is a shift in the line, or the so-called Lakshman Rekha, so to say, between adjudication and legislation on the one hand, and administration and adjudication on the other. However, I can confidently conclude that such cases have brought a new debate and dialogue on the transformative potential of the Constitution and the role of the constitutional courts, and particularly the Supreme Court, in a dynamic society such as ours. To this audience, I will briefly touch upon the phases of the PIL, because you would have otherwise studied it. I suppose the faculty is aware of it, the lawyers are aware of it, and the students will study it, but unless I touch upon it, my address would not be complete. The first phase of PIL concerned with conditions in prisons and other places of detention. The focus of the first phase was on exposure of repression by the agencies of the state, notably the police, prison, and other custodial agencies. Therefore, the court was looked to as an agency which would enable citizens to combat repression and government lawlessness. The court thereafter concerned itself with questions of social justice, including exploitation of bonded laborers and conditions of work and pay of unorganized workers. Spurred further, the court examined questions of land entitlements of poor peasants and thereafter engaged with environmental law. Human rights of prisoners subjected to torture, victims of police excesses, inmates of protective homes and asylums, and like concerns have drawn remedial attention of the Apex Court through PIL. The next phase promoted recognition and respect for social and economic rights. In People's Union for Civil Liberties, PUCL versus Union of India, the Apex Court did not merely issue directions for conceptualizing and implementing a centrally sponsored poverty and hunger alleviation program, but also appointed an expert committee to monitor the compliance of the court's order within a fixed time. The court expressed its deep anguish regarding the increasing number of starvation deaths and drew critical attention to the inadequate system of food security. The right to food was articulated as a fundamental right for the first time by disregarding the plea of the government concerning lack of resources. We all know that in 2001, the court, in a series of orders, mandated the midday meal scheme to be implemented in schools and the ICDS scheme also to be implemented, which also included immunization, nutrition, and preschool education programs. A prime example of this dynamism is the recognition of the right to food as a part of Article 21 of the Constitution, which in turn prodded the Parliament to enact the National Food Securities Act of 2013. In Olga Tellis versus Bombay Municipal Corporation, the court, speaking through Justice Y.V. Chandrachud, Chief Justice, progressively deciphered the holistic meaning of the term life as appearing in Article 21 to recognize right to livelihood as falling within the umbrella of rights under Article 21. The ambit of livelihood as a concept is no more confined to physical means of living, such as food, shelter, and clothing, but has evolved to include other basic necessities of life like education, medical care, livelihood, etc. Thus, it includes rights to live with human dignity, right to healthy environment, free education up to 14 years of age, emergency medical care, etc. In a series of cases, the Supreme Court has addressed the issue of health care being regarded as fundamental right and has imposed an obligation upon the state to create conditions necessary for good health, including facilities for basic, curative, and preventive health services. We saw how important this was during the COVID-19 pandemic since the years 2020. The right to primary education, being a facet of right to life, made the Parliament to introduce Article 21A of the Constitution in the year 2002 and to enact the Right of Children to Free and Compulsory Education Act 2009. Transformative constitutionalism, qua the right to life and personal liberties, had a tectonic shift in the views of the Apex Court in Justice K.S. Puttaswamy versus Union of India, as contrasted with its earlier view in ADM Jabalpur. In MC Mehta versus Union of India, the Supreme Court accepted that environmental pollution and industrial hazards were not only potential civil torts but also violations of fundamental rights redressable directly by the Apex Court through the medium of pill. The Apex Court has concerned itself with the industries polluting environment by toxic emissions or discharge of hazardous effluents, has banned felling of trees except in accordance with the guidelines, prohibit operation of shrimp culture located in ecologically vulnerable zones, and hence sought to protect natural resources as a custodian and trustee for future generation. The Supreme Court has accepted the sustainable development principle and has applied the polluter pays principle and precautionary principle as part of the environmental law. The Constitution is a transformative document and its transformative vision has several components, as I now said, liberty, equality, fraternity being among such components. Justice is, however, the chariot through which the transformative vision may be secured, and the charioteers are the judiciary, the executive, and the legislature. The judiciary, as highlighted earlier, is required to breathe life into substantive rights and freedoms. The judiciary should not take a back seat or leave it only to the executive or the parliament to come up with certain programs or schemes or rights, but itself must recognize the rights when there is a vacuum in certain areas of life or law. While transformative constitutionalism with regard to its meaning continues to draw debates in the face of various different experiences across the world, a key element that defines transformative constitution is the role of state, including the courts, in fulfilling the project of emancipation and constant development of the ideals of liberty, equality, and fraternity. It is these principles on which the society must sustain, and the state must play an active role in constituting a society based on these principles. I conclude by saying that to interpret the Constitution transformatively, we must understand the people for which it was made and for which it is continuing to apply, that is, the aspirations, the frustrations of the people, and the goals that they wish to seek, who are placed at the center of the agenda on the transformative constitutionalism. The tyranny of unfreedoms that restrict growth and development of an individual, such as systemic social deprivation, intolerance, etc., must be uprooted in order to unearth the true transformative potential of Constitution. It is in institutions such as this, the VM Salgaocar institution, where the Golden Jubilee is being celebrated, the mission of transforming our Constitution for the people by their syllabus and the manner in which they teach, that will lead to the students here to absorb what is required of them when they enter the legal profession, or just be, and even if they don't enter the legal profession, to become enlightened citizens. On that note and hope, I conclude my lecture. I once again thank the organizers for inviting me to deliver this lecture on a very intellectually stimulating theme. I thank you all for your kind attention. I hope I have not tested your patience too much. Thank you and namaskar. Sorry, it has taken a lot of time.